I am here to talk to you today about some legislation that is currently before Parliament and that we're hoping is going to become law by the end of this year. What is changing? We have the bill that's in Parliament at the moment, so if you're interested in having a look at it, is the Residential Tenancies Legislation Amendment Family Violence Bill. It's already been passed by the lower house and is currently scheduled to be debated by the upper house shortly. It will amend both the Residential Tenancies Act and it will amend the Residential Parks Act for on-site rentals, so where the person in the park rents both the accommodation and the site as well. So what it will do is we're trying to remove barriers for victims of family violence in terms of their rentals. I think one of the questions that we most hear in the space around family violence is, why don't they just leave? Why doesn't the victim leave? Why did it get to the point where there was serious harm or a homicide? And one of the biggest reasons why victims don't leave is because their tenancy laws don't let them leave. Okay, there's financial implications and there's legal implications for it. So what we're doing is introducing legislation that will aim to stop that. Okay, so what it will do. So it will allow a tenant who's been a victim of family and domestic violence to choose. They can choose to stay or they can choose to go. So it is focused on the victim of family violence. So a tenant who feels they need to leave because that's the safest option for them to do, it will allow them to terminate their interest in the tenancy agreement. If there's co-tenants, then the co-tenants will also have a choice after that as to whether they stay or leave, so whether the tenancy all wraps up or whether the tenancy continues. If the tenant who's been the victim of family violence feels that it's safe enough to stay, and often this is a better choice where there's children involved because it will allow the children to stay in their school. A lot of refuges where people might move to escape family violence are full. If you've got older children, they often can't take older males into women's refuges, so to avoid families being separated and broken up, it would be preferable in some instances for victims to stay in their home. And what this will allow that in that situation is that the victim can go to court and apply to have the perpetrator's name removed from the tenancy agreement so that the tenancy will be vested just in them. It will do other things, so it will allow the court to assign liability for any damage or debt to the person who's responsible for it. So for you as a landlord, it doesn't change how much money you're entitled to gather, it just changes who you can collect it from. So instead of collecting it from both tenants, it will say that the court will be able to say, tenant B is responsible for the damage to the walls and for unpaid rent as a consequence of family violence, and so tenant B will pay that to the landlord. And then the victim who's been the tenant who's been the victim of family violence won't be carrying that debt forward, because we know that debt is one of the biggest barriers to being able to re-establish in life in the future. The other thing that will allow the victim to do is to change the locks without having to first get permission. Again, one of the biggest complaints that we get through our call centres and the department is that landlords are not letting tenants who need to change the locks change the locks. What this will allow the tenant to do is it'll allow them to change the locks. It's their cost, they have to pay for it, and they will have to provide a copy of the key to the landlord within 7 days. There's penalties for them not doing that, but it means they just don't have to wait to get permission to do that in the first instance. That's helpful too where you've got landlords who what we call absent, so they live overseas or interstate or up north or something like that. We're also going to allow the tenants to make security upgrades. There's prescribed security upgrades, so that'll be things like locks on the windows, external lighting, it might be CCTV cameras, it might be an alarm system. These will all need to be installed by a professional where appropriate, so an electrician if that's what's involved. The tenant will pay for it. The tenant will have to make good the property at the end of the tenancy agreement. So it's their choice to put it in, their choice, they have to make good, but they don't need to wait for permission to do that in the first instance. So the aim being that we want them to be able to make the premises as secure as possible, as quickly as possible. And then the other thing that it will allow is a tenant who's been listed on a tenancy database who has been a victim of family violence, and that's the reason they're listed on a tenancy database, it will allow them to apply to have their listing on the tenancy database removed. So that will be up to the court. Now, what it means for landlords is we're not asking you to become experts in family violence at all. and we're not asking you to get involved in the family circumstances. There will be forms that will be given to you if the tenant wants to terminate their tenancy that will say, I've been a victim of family violence. There'll either be restraining orders attached to that or a report from a professional such as a doctor or a social worker or a psychologist. You as the landlord have to accept that. You can challenge it in court if you think the forms haven't been done properly, but you cannot challenge that family violence has occurred. And the reason for that is that family violence is such a complex thing, and a lot of the time you won't know it's happened. But we don't want to delay things and make people unsafe by tying up court processes and that. You will accept that it's happened. If there are co-tenants, then you'll provide a copy of the termination notice to co-tenants and pass that information on, but you also, any information about the actual violence, you'll need to keep private and confidential and keep it in a secure place. As I said, if there's damages and unpaid rent, it doesn't change how much you can collect. It just simply changes who you will collect it from. And this is why we're doing this. There's been a lot of, publicity in recent years about the scourge of family violence in our community. Nationally, we know that there's at least one domestic homicide a week in Australia. In 2015, 2016, 26 of them happened in WA. So that was one a fortnight in WA. We know that 40% of calls to homelessness services in Western Australia alone are from victims of family violence needing housing. They need ways to either get out of their tenancy or to be able to stay safe. So there's been 88 fatalities since 2012. We know that in 2016, 2017, there was more than 33,000 reported incidences of family violence. It's happening out there, and this is a major impact. So we really need to be able to make this a much more positive space, and we need these changes in the tenancy legislation to make a difference so that people who are victims of family violence can choose to leave or they can choose to stay, but they actually will finally have choices under the legislation. And what victims of family violence need is certainty of outcome, because at the moment they can apply to the court for hardship, termination of the contract on hardship grounds, or they can negotiate with the landlord and try and get out that way. But it's just never certain, and it takes a long time. And that often is a barrier in itself to a lot of people making the choice to leave. So we're taking away that uncertainty and creating certainty through the legislation. So I've talked to you about why we're doing this for tenants, but there are benefits in there for landlords as well. What it means is I imagine a lot of landlords at the moment, we know the stats are out there on premises being abandoned, and at the moment this is one of the most common ways that victims of family violence have to deal with their tenancy, is they have to abandon it because there is no other legislative way for them to deal with it. And I don't know if any of you in this room have had your premises abandoned and then all the hurdles you have to jump through to establish that the premises have been abandoned and to get them cleared out and then to be able to get the clearance to re-let them. That takes a long time, and that's a big cost on you. The process under this legislation is streamlined. You get notices, you'll get at least 21 days to know that the premises are going to be vacated. During that time, you'll be free to advertise and promote it to new tenants coming in. You know what's going to come, you know what's going to happen as a landlord. When premises are abandoned, there's a lot of periods of lost rent involved for you. Including an option for either party to stay or go, so either the tenant chooses to stay or you might have the co-tenants, the perpetrators choosing to stay, means that there's a very good chance that the tenancy will be ongoing anyway. We're just allowing one person to leave and giving that flexibility in the agreements going forward. As I said, you can re-let quicker. We've looked at some of the data, and we've got a case study that came through to us from down Mandurah way, where the woman was removed from the house by the police for safety reasons. The family tried to get her name removed off the tenancy agreement. The property manager kept saying no and wouldn't allow it to happen. It finally went to court, and the court backdated the termination to the date when they first asked, which meant the landlord was left with no rent recall for 9 months. Now, under our process, that would never have happened because you know exactly what's going to happen. It will reduce the risk of damage to your premises because allowing parties to separate and to go their separate ways because they're not locked in with contracts and financial burdens means that a victim can choose to leave or can have the perpetrator removed. The incidence of the violence happening in the home is removed. So it reduces the risk to damage to the premises. And as we say, we're not overstating it, I should say, in saying that as landlords coming on board with this legislation, you are saving lives. As I said, 26 domestic homicides in Western Australia in 2016, 2017. That's one a fortnight. Now, if we can allow those people to more easily extricate themselves from a violent relationship, that's you contributing to safety in the future. This is a question, and it's a very valid question that we know landlords are going to be asking us, is what about the tenants who will be rorting the system? What about the tenants who will just simply claim family violence as a means of getting out of a tenancy agreement that they don't want to be in? We've built in some protections. So if the victim wants to terminate their own interest in a tenancy agreement, they have to either have a restraining order or a form signed by a professional who has worked with them to say, yes, I acknowledge that they are a victim of family violence. So that'll be a police officer, it'll be a social worker, a doctor, a psychologist. It's not the tenant themselves in their own right saying, I'm a victim of family violence, let me out. But at the end of the day, we also had to look at the balance between making it so hard by trying to stop people rorting the system that we actually then make it too hard for the genuine victims to leave a tenancy, versus saving saving some rent for the landlords who might be losing out on a tenancy early inappropriately. And really, that's the balancing act that we were faced with in this legislation. If we make it too hard, it could be someone's life versus 3, 4, 5 weeks rent for a landlord. And I know it's trite for me to say that because I'm a government employee and I'm not the landlord that's sitting here in this room, but that ultimately was the balancing act that we had to come up with. We have been in touch with some states in Canada that have very similar legislation to us, and in fact, in one state in Canada, they don't even need that third-party report signed. It's the tenant themselves saying, yes, I'm a victim of family violence. There are penalties attached if they make a false claim. In 2 years, they've not had one allegation by a landlord that a tenant's making a false claim. It's not something that people will easily... Put yourself in their shoes. Would you sit there and say, I'm a victim of family violence? There's so much stigma attached to it. I really don't think people are going to claim it in order to get out of their tenancy, okay? And not only that, if you think about having to move, the 4 weeks rent of a bond, 2 weeks rent in advance, removalist, it's not cheap. People don't move just because they want to, for the hell of it, okay? So we're weighing up all of these risks at the end of the day. And what I want to just play for you in a second is we have landlords, we have tenants come to us, but this is a little...
I would honestly say to the landlords,
snippet. This is a little snippet from a tenant who has been to us in the department to have us conciliate with the landlord with them. She's had to leave the house because it's too dangerous for her to stay in the home, and she was actually assaulted in a home, so she even just doesn't want to be there. She's asked the landlord to let her out of a lease, and the landlord said no. And in fact, I think for another thing in terms of benefits for you as landlords too, a lot of landlords are telling us they really would like to let the tenant out of the lease, but their insurers are telling them they can't. With this new legislation, that won't be a problem because this is a valid, lawful termination of the tenancy. Your insurance is then not an issue, okay? You're not going to invalidate your insurance. So, but in this instance, the landlord has said no, they're not letting the tenant out of the tenancy. And she's actually now being taken to court for unpaid rent, even though she can't live in the house. It's not safe to do so. So I'll just get you to play.
I would honestly say to the landlords, put yourself in our shoes and feel what we have to feel and go through what we have to go through. So yeah, I would just say to those landlords out there, just have a little bit of heart and just have a bit of consideration because it is hard.
So it is I've given you a very short snippet of what the legislation is going to do. We do have a dedicated webpage that you can go to and that'll give you more insight into legislation. There's also a link on there to the actual legislation in Parliament so you can read more about how it's going to work. We also have e-bulletins that for landlords, for private landlords. It's a free e-bulletin that comes out, I think, on a monthly basis or fortnightly, but I'm not sure how they come out as needed, but there's definitely regular ones. We have two of my colleagues at the back room here who can take your details down if you want to subscribe to that e-bulletin, and that will give you updates on the legislation as well as lots of other really helpful information for private landlords. But definitely if you go to the website, then you'll be updated on that information as well. Thank you.